my dog.
Not WeWork's dog.
No, it was mine.
Hey, Ria.
Hi, I didn't realize I was unmuted and he went crazy.
Sounds like you're having a rough day, pun intended. I got a reaction.
Very good. Yeah, I'll record the event. Normally you get a lot of people that tune into the recordings after, which is good. Ollie, great camera, mate.
Awesome. I reckon it's we'll probably kind of kick things off from here, and there'll probably be like a couple who trickle in a little bit later, running on startup time very much so. Folks, thank you so much to the kind of crew of founders who kind of came in for this session today. To kind of set some context, we're lucky enough to actually have a direct panel with Alex Soll himself, founder of Sprintlaw, who are kind of a law firm, but not one of those lame law firms, one of the cool law firms. They're startup-y and stuff. Part startup, part law firm. Alex, is that a fair assessment? Somewhere in between.
That is a fair assessment. Yeah.
Yeah, and it's a super cool model. So yeah, Alex and I kind of connected. It was about a month ago or so. And I was just super impressed by kind of the very forward thinking approach that they were taking to kind of advising smaller businesses on legal challenges. Very personally for Earlywork as a startup, I know we really struggle to get our heads around what the hell are you meant to do when you're starting a business? What do you need to have in check in terms of, whether it's trademarks or whether it's shareholder agreements. I think for a lot of founders, legals are something that you don't necessarily think about super early on, but if you neglect them early on, there's a chance you could really, really screw yourself over. And that's why, yeah, super stoked to be able to kind of do a talk with Alex, which will also record as kind of an asset for the community going forward. So the kind of founders in Earlywork are able to get a sense of, how the hell to approach legals when you're starting a business. But I'll hand over to Alex, who can talk about things in much better detail than I can as a non-lawyer.
Awesome. Thanks for the intro, Dan. Hello, everyone. To those here and those watching this recording in the future, I'm going to run through today a presentation which we call Business Legals 101. So the idea of this presentation is to basically give you a high-level helicopter overview of all the different sorts of legal things that you want to be thinking about when you're setting up a startup company or working in a startup company. So we'll go through all those different areas. We've got, I guess, a small crew here. Maybe if you can use the show of hands feature, how many people in our little audience here are founders of companies or side hustles or something at the moment? We have four, a few actual hands raised. Might be good. Before I get into it, it'll help me get a sense of what to emphasize. Maybe if you guys could give me a little bit of a rundown of what your businesses do. I don't know, Oliver, if you want to start just a quick summary of what you're working on and what your company is.
Sure. So basically what I'm working on is called Green Code. Green Code's a next generation plasma coding smart window solution that changes the opacity of windows in real time to, basically reduce reliance on HVAC and provide a passive form of heating and cooling for buildings.
Awesome. That sounds like a cool concept. And where are you at in your business journey? Have you just started or been doing it for a little while?
Yeah, we've been doing it for a little while. And we're doing a lot of research and development at the moment. And we have a very rough prototype, but we want to improve it even further. So we're sort of more towards the beginning of our very exciting journey.
Love it. Awesome. And Ashish, I think you might have put up your virtual hand. If you're comfortable sharing,
Yep.
Would love to hear a bit about what you're doing here.
Yeah, hey guys. So I'm working on an EdTech startup. Essentially right now it's helping high school students figure out what they want to do after school. So basically your career counselor helps you out a bit, but realistically you don't spend much time with them. So we go into one-day programs and big topics like business and commerce, ID, computer science, and 6 other kind of big fields, and basically try to get the students to actually discover some of the interest before actually locking in some of those decisions.
Awesome. That sounds like a cool concept. Hey there, Joshua. I think you've just joined us. We were just chatting. I'm the founder of Sprintlaw, so legal firm. I'll be doing a presentation on Business Legals 101. But are you a founder of a startup company or any kind of business? And if so, we'd be keen to hear a little bit about it because it'll help me work out what to focus on.
Yeah, thanks, Alex. Hi, everyone. Josh here. No, I'm not really a founder, but I am playing around with just building something myself in my own time that I think may have some potential in the future. So
a future potential founder, yes.
Yeah, hopefully. And yeah, it's basically toying with the idea of a new social media site. I promise it's not a copy of Facebook or Instagram. It's a fresh idea. But yeah, it's still kind of in the early phases of it, building it out. But I'd be keen to hear if you're looking for guidance on the session, keen to hear from the perspective of like early ideas, how to like maybe protect them, or at what stage you do that, or any risks and stuff. So yeah, thank you.
Sounds good, and yeah, good to know. And yeah, we've got more people joining, so maybe I won't continue to go around the room, but maybe Dan and Jono, for you guys, obviously, I think everyone kind of knows what Earlywork does, but keen to hear from your perspective in setting up the organization. What were some of the legal headaches that you guys faced or encountered in your early days?
Jono, Chief Legal Officer, I'll let you take this one.
I'm internally the Chief Handshake Officer that looks after the more mundane parts of the business, to quote an SMH journalist. And yeah, no, I sort of set things up on a whim without really knowing much, and some of which has caused headaches down the line and sort of choosing the amount of shares in your business and how you split them up and that sort of thing. So, but thankfully, I think we undertook a capital raise, and that process, I think, is something of which you can't do by yourself. So definitely recommend getting lots of legal experts to help you out there, because that's a challenging thing. But yeah, setting yourself up for success legally is probably one of the most important things you can do, because you can really hamstring yourself if you do it the wrong way. So lived and breathed it thus far.
Awesome. No, that I agree with all of what you just said. And yeah, capital raising is the time which for many startups is when all of the legal stuff comes to bear, all of the headaches of getting the deal done, which it sounds like you recently went through. So if we get time, I'll cover a little bit of that for everyone. I might just share screen and start running through the slides. Can everyone see that okay? Yeah, awesome. So here is Sprintlaw's cool logo. Just to tell you a little bit about who Sprintlaw are before we get into the educational stuff. We're an online law firm really made for startups and small businesses. You may have heard sort of traditional lawyers are the kind of service provider that traditionally sort of charges you for everything, charges in these 6-minute increments and those sorts of things. Our mission with Sprintlaw was really to design a much more affordable but still high quality offering for smaller companies where they don't have to worry about being charged for every little thing. And we've kind of simplified the way that law works with Sprintlaw into a couple of key offerings. Most of what we do are provide fixed fee legal work. So if you need some piece of legal work, you come to Sprintlaw, we give you a quote, that's the price, and we'll do it for that price. That might be setting up a company, registering trademarks, doing terms and conditions, privacy policies, those kinds of things, whatever kind of legal work you need, there's a quote for it. And then we have a subscription offering, which is kind of an optional add-on, which a lot of our customers sign up for if they want to build a long-term relationship with us. And it costs, I think, about $7.99 a year. And as part of that, our startup clients can chat to a lawyer whenever they want. It's got like a helpline with unlimited quick chats, and then you get discounts on any of your fixed fee legal work and some other things as well. So that's the basic model of Sprintlaw. Just a quick snapshot, as Dan mentioned, we are both a law firm for startups and a startup ourselves. We've been around for about 5 years, so fairly young, not as young as we used to be. We're getting old fast, but have been growing pretty fast, and have been in some of these fast starter lists, the AFR fast starters list, and the Deloitte APAC Tech Fast 500 for our fast growth. So the team's about 45 staff. We got a bit over 3,000 clients. We're in Australia and recently launched in the UK as well. Have raised investment ourselves and are very much on that sort of startup journey. So have kind of been through it ourselves, and that helps in the way that we talk about the legal things and how they fit in, because we certainly understand it. So in the session, I'm going to be covering a whole bunch of topics, talking about co-founders, structuring your business, how to think about compliance and regulations, contracts, intellectual property, so protecting your IP and ideas and things like that, hiring, so employment law things, and then raising investment. As I'm going through it, feel free to drop any questions that you have in the chat. I'll leave some time for questions at the end. But if there's particular things that you want to know, I mean, you know, this is kind of an opportunity to get some free legal advice, although you can't hold me to what I say. So, but do use it if there's questions or things I haven't explained very well that you want a bit more info on. So just before we go into all of those different things in the contents, though, I just want to start by talking about, like, big picture. How should startups think about legal stuff? You know, law is a thing that if you're starting a company, you've got a cool idea for a startup, and you're excited to be working on your business, thinking about speaking to a lawyer is definitely not the thing that's at top of mind. It's not the thing that is actually naturally going to even come up in your business unless you hit a roadblock or you hit a situation where someone tells you need a lawyer. It's actually an easy thing to forget about, but then it can come back and sort of bite you later for not having done it. And I think a lot of people think that lawyers are about complying with the law. I don't want to be breaking the law, so I need to speak to a lawyer. So I make sure that I'm not doing anything that I'm not allowed to do. That is one aspect of legal stuff, but really I think there's kind of three ways you want to think about legal work or legal needs if you're building a startup company. The first is it's about risk management, being protected. So what legal services do and what lawyers help you do is they help you go into business protected against risks. Risks may not happen, but they may happen. Some risks are likely to happen, some risks are unlikely to happen. And many risks that are unlikely to happen could be business-ending risks. So even though there's a low probability of them happening, if they do happen, they could actually be quite disastrous for your company. And these low likelihood but high impact risks are often things that kill startup companies 1-2 years in. They didn't think about the legal stuff early on. They thought that would never happen to me, or they didn't even know about it. And then they find out 2-3 years in that there was this big issue they should have thought about at the beginning, and the whole thing kind of falls apart. So a big part of speaking to lawyers is about risk management. You can almost think of it as like insurance. You go and get insurance on your car. So in the unlikely event of a crash, you're glad you got insurance. What lawyers can do is they can help put the pieces of the puzzle into place. So in the unlikely event of a business issue, you have risk protection. And that's what we do through things like contracts, limitations, liability, business structures, intellectual property protection. These things are to protect you from things going wrong. Put the shield up, if you will. So that's really, I think, one of the key ways you should be thinking about legals. There is, though, some other aspects to using lawyers, which people often overlook. One is lawyers can actually really help you get a good deal. It is possible, for example, with contracts to sign up a web developer or an app developer to create your piece of technology yourself without speaking to a lawyer. You just find someone, they give you a quote, you pay them. It's possible to take investment in your company without seeing a lawyer. Someone hands you a contract, you sign it. It's possible to set up terms and conditions using an online template with your customers. And that's how you do business. That's your customer T's and C's. All those things are possible. But in addition to the advantage around risk from lawyers can actually help you get a good deal. We see lots and lots of different types of deals that happen, contracts that happen in business. We've seen heaps and heaps of investments, for example, that happen into startup companies in Australia. So if you receive a contract, we can tell you whether those terms are usual or unusual based on what we've seen. We can tell you whether there's things that you can actually negotiate on when you didn't even know about them, or creative ideas to help you design a deal that actually works out financially better for your business. A simple example of that, which is not super sophisticated, but often we're designing app development agreements for people getting technology built. And app developers will hand their standard service agreement to a startup and they'll say, sign this contract, we'll make you your app. Hidden in the fine print is all kinds of hidden fees for, if you ask us to do stuff that we didn't discuss up front, we'll charge you this much more money. if the thing doesn't get accepted by the App Store, it's not our responsibility, so on and so forth. Lawyers can actually pick up those issues and price in those risks. We can say, this is what we're paying for. This is what's agreed. If you guys don't deliver the app on time, we're going to charge late fees. Yeah, we're going to get discounts for late delivery. If it doesn't get accepted by the App Store, we're going to get some sort of discount. If there's bugs we pick up 6 months after, you have to fix it for free. So these are the kinds of things which, lawyers can actually help with the design of a deal. And so another reason where you can actually get a bit of a return on his investment by speaking to a lawyer. And the third aspect is avoiding disputes. And that's kind of a subset of this whole risk management thing. But a lot of times people will do business with a handshake agreement. Two business partners will get into business together without a contract, or people will sign up customers and just start doing work together. And it's actually quite rare in the startup environment for people to sue each other. No one really has money when things go wrong to be suing each other. Startups don't necessarily have any money to be sued for. So in the early days, it's kind of unlikely that you're going to get sued because something went wrong. But actually what disputes do, if they occur, if something wasn't agreed up front in writing, is that they cause all kinds of headache and stress and confusion, and they can really kill the momentum of a company, or they can create reputational risk and cause all kinds of other non-financial issues. And a lot of disputes can be avoided by actually having documented agreements and conversations up front. And so we find, particularly with business partners, I'll talk a little bit more about that on the next slide, but we find a lot with business partners that, a lot of people will set up a company and two founders will think they're on the same page. But a year and a half, 2 years later, they find out that they had different visions for the business or different expectations of what they wanted to do. A lot of that could have been avoided if they'd actually had a conversation up front about what their goals are, what they thought should happen in different scenarios. And lawyers have a good checklist of some of these issues. And so if you discuss these things up front, you can actually help avoid disputes in the long run. So hopefully that's a little bit of a taste of how the lawyer fits into the startup and broadens your expectations of when you might want to be using a lawyer. But let's just chat about probably the first step in setting up a company is thinking about, who are you actually in business with? So let's say you've got a new startup idea. If it's just you, just starting the company by yourself with no third-party support, this slide is actually not super relevant. But for the vast majority of companies, there's usually some other stakeholders fairly early on in the business. Either there's two people wanting to do business together, so some co-founders. There's investors that might be investing in the business either early on or maybe a little bit later, or maybe there's friends and family that might also be investing in the business in some way. So if you're setting up a business, probably one of the first things you want to do is have those conversations around what's the roles and responsibilities of each of us that are involved in the business? What are we hoping to get out of this thing? What happens if it all falls to pieces? What happens if one of us wants to continue, the other one doesn't? These kind of conversations are pretty important. There's a legal document that you often do very early stages. It's called like a founder's term sheet, but the real document is called a shareholders agreement. And it's an agreement between, usually between different founders and the other people involved in setting up the business, that just sets out what everyone's going to be doing, what's going to happen in different scenarios, what happens if one person wants to leave but the other one doesn't, what happens if someone wants to sell their stake to some random third-party person, who's allowed to do what, who's in charge of making decisions. Can one founder make decisions without the other founder's approval? Do they both need to sign off on things? How's all that stuff going to work? So this is kind of what I was alluding to with avoiding those disputes up front. Having a documented shareholders agreement or founder's term sheet or something in writing from the very beginning, just to document who's doing what and what the expectations are, can help set good ground rules for the future, help avoid those disputes, and have a really good founder relationship. And we do see lots and lots of companies start with a set of founders, and as they grow, founders drop off, founders leave. Having really clear documentation from the beginning can help have guidelines for what will happen in that scenario. If you don't have anything in place, you end up with these unnecessary disputes because founders think that they were really important and they're leaving, they should still get X, Y, and Z. Other founders think, well, you're leaving too early, you shouldn't get X, Y, and Z. And had they agreed up front, you actually would have had no issue. So yeah, very important to have those conversations up front and ideally document them in some sort of agreement. The next aspect is actually setting up your business. So let's say you've got an idea for a company or a business, and you want to work out, how do I actually register this thing as a business operation? How do I start doing things? How do I start getting customers, making money, and growing it? Well, the first thing you have to do is select a structure for your business. There's kind of two basic structures, and there's more sophisticated versions of these that I'll talk about in a minute, but two basic structures that every startup business owner is thinking about in the early stages. The first is setting up as a sole trader, and the second is setting up as a company structure. There's a third structure called a partnership and a fourth structure called a trust. I'll talk about a little bit later. But partnerships are very uncommonly used in sort of startup in the startup ecosystem for reasons I may go into a little bit. But the basic decision between being a sole trader and a company is, if you set up as a sole trader, it's quick, it's easy, you just go online, fill out a form, you get an ABN. Once you have an ABN, you can start doing business. You can register a business name for your ABN, and you can start taking on customers and doing things. The thing with being a sole trader is, if there are issues in the business that you've just set up quick, easily, cheaply online yourself, you can actually be personally liable for any issues in the business. So, let's say you take on a customer, something goes horribly wrong, the customer decides to sue you. They can sue, they've got a contract with you, so they'll be able to sue you, but also, if you can't afford to pay what they sue you for, they can come after your personal assets, your house, your home, your car, your electric guitar, whatever it is. You're personally liable for issues that emerge in the business. So the sole trader structure, while it's super quick, easy, simple to set up, it's really used by like side hustle businesses or very, very small businesses, or people that haven't really got going yet and just needed to set up an ABN so that they could, make a bank account or something. But not really the sophisticated structure you want to be using if you've got big ambitions for your company. The structure that's used by most startups is a company structure. When you set up a company, you're actually setting up a separate entity, almost like a separate legal person to yourself. So, there's you and maybe your co-founders, and then there's this thing called the company, which has its own kind of identity. So you'll often name your company. So at Sprintlaw, for example, we have Sprintlaw Pty Ltd. That's our company. And then there are shareholders, so the people that own the company, which is usually the founders, and you'll split the ownership of that company by some percentage, 50-50, 60-40. If there's 3 people, maybe 33% each. So those are the people that actually own the company, and they're called shareholders. And then separately, you have directors. So the directors are the people that control the company, which may not be the same people as the shareholders in a company structure. It doesn't have to be the case that the owners of a company and the people that control the company are the same people. Often they are. In early stages, the founders will be the owners and the controllers. But the distinction is, the owners of the company are entitled to the dividends and the profits of the company. If it makes profit, it gets split between the owners of the company and some percentage. The directors of the company are the ones that are almost like the arms of the company. They can make decisions on behalf of the company. They can sign contracts. They can open bank accounts. They can, basically execute the functions of the company as if it were a person. So the shareholders cannot make decisions, but if you're just a shareholder, you cannot necessarily make decisions on behalf of the company. You can't sign contracts or anything like that. What you can do is vote on who the directors should be, and then the directors are the ones that go out and actually sign contracts. A quick question here from Josh. Is it easy or recommended to start as a sole trader and then switch to a company? Look, it depends on what your business is. Most lawyers would tell you that you're better off having a company from day one. It costs a little bit of money, but it's going to save you on admin in the long term, making the switch. To give you an example of what the admin would be, if you've opened up bank accounts under an ABN, if you've signed up to contracts and done deals with various people and it's all under your personal ABN, you're going to have to re-sign all of those documents, switch over your bank account, do all this administration just to switch to the company structure. So that's really the main headache of switching over. And obviously the other thing is, every day that you're a sole trader, you're at risk if something goes wrong of potentially being personally liable. So that's the decision. I mean, if you're just exploring an idea and just want an ABN to do a little bit of testing, it's probably okay to be a sole trader, but just be aware that the more stuff you do as a sole trader, A, the longer you're doing it, the greater the risk, and B, the more admin headache you're going to cause yourself later when you need to switch over. So yeah, I would say do it early on, but some people don't want to pay the $1,000 or whatever it is to set up a company, or you can do it a bit cheaper these days. Yeah, good question though. So yeah, that's the distinction between the sole trader and the company. The sole trader is potential personal liability. The company is a separate legal person with independent owners and directors. Although, as I say, in the early days, most of the time, the founders are both the shareholders and directors until such time as they maybe take on investors, at which point they might have other shareholders and maybe some other directors as well. I won't go into this slide in too much detail because it's a little bit more complicated, but we've got these kind of two high-level options between the sole trader and company. Now, with the company structure, when people are setting up their company structure, they often do more sophisticated things than just set up one company. The most common structures that we see startups use, particularly ones that have ambitions to grow and scale, either this dual company structure or this trust structure. So I'll just quickly explain the differences. A single company structure is, there's one company and you have, the founders and the investors, if there's any. And by the way, these are the shareholders that we're showing up here. These are the shareholders or the owners of this entity. And this entity is the entity that does everything. It's the one that opens the bank account. It's the one that employs staff, enters into contracts, holds intellectual property, all that kind of stuff's done here. The dual company structure is a method where you can actually split the one company into two companies. So you have an operating company. It's owned by another company called a holding company, which is then owned by the shareholders, the founders, and the investors, and so on. Why would you bother doing this, particularly given that it's likely to cost twice the money to set up? Well, the main advantage is that it's further adding more risk protection for your business. If you've got really valuable IP, let's say you're building an amazing piece of technology, or you've got some trademark that's worth a lot of money, or you've got heaps and heaps of cash that you've gotten from some investors, you ideally want that stuff to be protected from risk. You want that stuff to be not potentially liable to anyone that you're doing business with. So what you'll often do is you'll set up a holding company, then you'll have an operating company. This is the company that goes out and operates your website, signs up to contracts with customers, employs all your staff. Something goes wrong down here, an employee sues your company, a customer sues your company. They can come after this company's assets, but they can't come after this company's assets because it's a separate company. It's a sort of siloed risk, if that makes sense. And so often startup companies will do this because they know they're going to be investing millions and millions of dollars in building some amazing piece of technology or whatever it is. And they don't want one mistake they make early on, signing up a bad customer or doing something wrong, to potentially put the whole thing at risk. So very common to do this split. There's a more advanced version of the split where you see founders. So it's exactly the same. We have the two companies, but the actual shares that the founders are holding, and potentially investors too, are held through a trust company, which people often do because there's tax benefits and also some other risk benefits. But I probably won't go into that in too much detail now. Ashish, you've just asked, can you have a single company with a trust structure? You certainly can, and some people do. I think it's more common to have a dual company without trust structure. The dual company really has a very big risk advantage because most businesses will have, risky contracts they enter into and then really important assets. And so this is probably, I would say, in your early stages, more important than this one. This one gives you some tax benefits and some insulation of liability against other other founders. That's the advantage of the trust, which I didn't really talk through. But yeah, it's like, if you're going to bother setting up a more expensive structure, you may as well do both, is probably my view, which is why it's not super common. But you can certainly mix and match those two. So just moving on to regulations. So once you've got your shareholders agreement in place, you've worked out which company structure that you're using, you've got your dual company structure set up. For a startup, one of the very first questions you want to be thinking about are there any regulations in my industry? Are there any regulations I need to know about before I even get started doing business? The thing with regulations is they're quite important, because you may have an amazing business idea or business concept, but if there's a piece of law that says that ain't possible, then you need to go back to the drawing board and either change your idea or think of something else. And again, it's a very basic point, but a lot of people don't do the exercise of actually looking into the laws properly early on. You don't really need a lawyer necessarily to do this unless you're working in a very complex area. Most industries have like an industry body that has a bunch of information, regulation, a regulator who's summarized all of the key laws you need to know. If you're working in the childcare industry, there's an industry body that has a whole bunch of information on working with children checks and those sorts of stuff. Or if you're working in pharmaceuticals, there's the TGA that has a whole bunch of information on that stuff. Or alcohol, there's a regulator that will tell you about, alcohol sales and packaging and those sorts of things. So you should really get familiar with your own industry's regulations quite early on. For us, we're setting up a legal, sort of different kind of legal business. There are regulations that affect us around payments. It affects the way that we can collect payments. We knew early on we wanted to be an online legal provider that was kind of like an e-commerce experience. You could just pay up front and then, get your service delivered to you. Sounds straightforward, but in our industry, there's a whole bunch of regulations about lawyers taking upfront payments. And so it actually cost us the first 6 to 9 months of our business reformatting the business model so that we could actually do things this way. And it was compliant with the regulations. And if we couldn't have gotten around that, we might have never been able to get started. So, and if we'd waited 2 years to find that out, well, we could have been shut down or fined by the regulator. We've actually seen a lot of customers who are doing something innovative, who are doing something new. It goes hand in hand with the space. If there's a reason that if it hasn't been done before, it's very possible that one of the reasons is it's because it's not legal, if that makes sense, or there's some legal problem. And so this is why it's very important to just do the sense check early on. There's usually a way around a regulatory issue by changing your business model, but definitely don't forget to check the regs, would be my main piece of advice there. The next thing to think about is the contracts that you need for your business. So you're set up, you've checked that there's not some piece of law that says you can't do this thing. You're building your product and you're now thinking about, okay, well, how am I actually going to get customers start making money, and how's that stuff going to work? So pretty much every business will have customers of some sort and then service providers or suppliers of some sort. If you're, an app business, then your customers are the users of your app, and your service providers and suppliers are, your app developer that helped build your app. Or, if you work in an office space, a supplier might be, the provider of the office space. If you're Sprintlaw, your customers are your clients, your service providers are, who do we use? Our accountants or whatever. If you're a cleaning service, then it's your cleaning clients, your customers. Everyone has customers of some sort. And every time you have customers, you should be thinking about, how can I protect myself from risk against these customers? If something goes wrong with my customers, what can I do to protect myself? The most common thing that you can do is have some kind of contract with your customers, which will help limit your liability to your customers if things go wrong. If you're an app company, those are your app T's and C's. If you're, a cleaning company, that's your cleaner's service agreement or cleaner's T's and C's attached to the back of your invoice. They're the same document, basically. You'd be surprised how similar a cleaner's service agreement and an app T's and C's actually look, because they're both customer contracts and they're both about protecting against risk. And so what these documents do is, if something goes wrong, the app breaks, someone's hacked, the cleaner breaks something while they're cleaning, the customer's really angry and they say, I've lost all this money, I'm going to sue the crap out of you. What the T's and C's can do is the T's and C's can say, well, look, you're paying us this much for this app, or you're paying us this much for this cleaning service. If things go wrong, yes, you can sue us, but we're going to put a limit on the liability. The most you can get from us is a refund, or a little bit more than a refund. You can't get $2 million off us if we just, even if we broke $1 million vase, that doesn't mean you can claim the $1 million vase because you only paid us $100 to clean your place, if that makes sense. So the contract can actually save you $1 million in the scenario I just gave, simply by having a very effective limitation of liability clause that says what happens when things go wrong. It can also have other things in there, payment terms. It can set out what happens if a customer doesn't pay you on time. You can have late fees, these sorts of things, and the right to stop providing a service or stop providing things, if you're not getting paid on time. So it has a whole bunch of different benefits. It basically will set out all of the T's and C's with your customers and can set out how your service works and protect you against all the different kinds of risks. And so we often refer to contracts as the lifeblood of your business, if that makes sense. And if you think about the layers of protection, we're talking about this company structure as opposed to the sole trader. The big advantage being, well, no one can come after your personal assets. They can sue the company, but they can't sue you. So if you've got a company that then is engaging a customer through a contract with a limitation liability clause, you have two shields before anyone can get back to you. You've got a shield against the customer even being able to sue the company. And then even if they could get through your limitation liability clause, they still can't come after you because you've got that company structure. So very important to set out those customer T's and C's. On the service provider and supplier end, you're their customer. So you want to be checking their contracts. They might make you sign up to things that say kind of what you're trying to say to your customers. Hey, we're going to provide you this service of, hosting your website. But if we crash your website and everything goes down, the most you can sue us for is $100. If the website is super important to you in the scenario I just gave, you want to make sure you check the contract with the website host to make sure that if they're not providing their essential service to you, they have more than $100 liability. There's other advantages of the service provider contracts or supply contracts. Basically, if they're doing anything essential to you, you're going to want to make sure that they're obliged to do that they're delivering to you what you need. One of the most common types of supply agreements that we do is for e-commerce companies, so people that are, shipping goods or services, selling goods or services online to customers, and then they will import goods in bulk from a wholesale supplier or something. They've got really good customer T's and C's. Customers make a whole bunch of orders. Maybe it's Christmas time. There's a big rush. And then they go to their supplier, hey, we need a bigger supply of these, shoes or whatever the product is. And the supplier says, oh, sorry, I can't give them to you. And the company is completely reliant on the supplier, has a whole bunch of angry customers, can't fulfill orders, has to refund, loses money. It's a disaster. A supply agreement can help prevent against that, either by requiring the supplier to promise to deliver things by a certain period of time, providing discounts for bulk orders, providing refunds themselves when they don't deliver things that they promise to deliver, and help kind of protect you if you're very reliant on them in your business. So this is kind of how the whole contract story fits into thinking about things. And for most startup companies, one of the first pieces of work that we do is, they're setting up their business and they want to contract with their customers. So it's probably one of the most common things that startups need. And as they grow, they start to look a bit more at these areas once they've worked out who their suppliers are. Next, we can move on to intellectual property. So this is, I think, one of the most common areas people know that they need to think about, but don't really know where to start. So when you're setting up a startup, there's really 4 types of intellectual property you want to turn your mind to. And these are the kind of 4 key areas you want to be looking at protecting for your business. The first is the trademark, and in some cases a design. A trademark gives you the exclusive right to use a name, logo, or phrase in a particular country, in a particular class. So it's the way that you protect your brand name. That's what trademarks are really all about. It's about brand name protection. So for example, for Sprintlaw, we have a trademark for the word Sprintlaw in Australia, the UK, Canada, and a few other places. We have a trademark for this word Sprintlaw in the legal class. It's class 45, I think it's called. So That means no one else in the legal industry can use the words Sprintlaw or anything that's very similar to Sprintlaw, Sprint lawyer, Sprint legal. There's a whole bunch of laws on what constitutes similar, but if it's too similar, they can't use it either. Sprint legal vision. That's a good one. Yes. Well, that's questionable, but if it's too similar, they cannot use it in your industry, in your class. And if they do use it, then you as the trademark holder will be able to sue them, if that makes sense. Now, it only protects you in the legal industry. So if someone decides to set up a restaurant called, Sprintlaw that makes cold slaw or something, that is not in the legal industry. It would be a terrible name for a restaurant, but it wouldn't necessarily be infringing our mark because it's in a I'm just laughing at the comments, but yeah, in a different kind of class. But yeah, they can do that. But if they try and do it in your class, in the legal class, that's where they may be infringing your trademark. The other aspect is it's geography based. So if you're going to be an international business and go to multiple countries, you really want to get your trademark done early on. We had a long-term client of ours that I won't tell you their brand name, but they grew from a tiny company to a multi-million rev business within a couple of years. Thought they were only going to be Australia focused early on, weren't sure whether they were going to go overseas. Launched in the UK, had forgot to register their trademark there, and were growing really fast. It was all very exciting, and then got a letter saying, "Hey, we own this trademark in the UK. We're going to sue the crap out of you for trademark infringement." And it put the business on hold for about 2 years because they couldn't rebrand. Their whole manufacturing and supply lines were based around this particular brand, and they were delivering these products. It would have cost them a huge amount of money to have a different brand for that market, and they ended up having to, for an inordinate sum, actually buy out the trademark of the UK business. And if you looked at the registration date of that UK trademark, it had actually happened after the Australian trademark. And so had they just remembered early on, we might go overseas to register in multiple countries, it would have prevented that issue. And that's like one story. I mean, because we're lawyers, we see all of the worst case scenarios, but seen lots and lots of startups forget to do the trademark early on. I mean, my view on it is, if you got a brand name, a business name, and you love it, and you're about to invest all this money in building an app or building a piece of technology or building a company, and you don't protect it, it's like so risky. Mahalio's asked, how much does it cost? With Sprintlaw, we charge, I think, $1,000 or $950 plus GST to register a trademark. That's for one mark in one class. It is, again, possible to do it yourself, probably a bit risky. That's what happened with that company that forgot to register in the UK. They tried to do it themselves, and then it kind of bit them. So you can do it for about $500 or $600 if you do it yourself, or it's $950 with lawyers. But for the importance in the business and the cost, it's kind of like one of the no-brainers that, when we set up Sprintlaw, the first things that we did were register the company and then trademark the name. And we didn't really start doing very much else until we got the trademark through. So if that's what the lawyer startups are doing, it's probably a good idea for most people to be thinking that way too. Designs I won't really go into, but if you've got a product, so designs are not about like graphic designs or those sorts of things. But if you've got a physical product like a piece of furniture, or you've designed an innovative shape of a bottle or something, you can actually register that design in the same way you register a trademark in a particular class in a particular industry. And then that no one else can use it as well. So for product companies, it can be a really useful way of protecting their IP. So that's trademarks and designs. About brand, and in the case of designs, product protection. Copyright is where you start to get closer to protecting the essence of what your company is. So copyright is a bit different to trademarks. Unlike trademarks, you don't actually register them. You don't register them in industry or a class. You don't get a number. What you actually get with copyright is the second that you create an original work recorded in material form, you will own the copyright in it. Don't have to register it anywhere. The creator of the original work recorded in material form will actually own the copyright in that creation. So the big question is, what is an original work and what is material form? What do those things mean? And there's a whole bunch of lawyer talk around what those things mean. But in essence, an original work is something that you've come up with that has some creative element. It doesn't have to be groundbreaking. It doesn't have to push forward human progress or anything like that. It just has to be original. This presentation that, I've created, it may not be the most original thing of all time, but it's original work, wasn't done by anyone else. It was created by me with some help from one of my team members. So when we created this thing, it would have ticked that box of being original and creative enough to be potentially copyright protected. And then the second criteria is material form. It can't just be, I had an original thought, bam, I've got copyright in it. You actually need to document it somewhere to get copyright protection. So material form doesn't have to be a piece of paper, although a piece of paper will do. It can be electronic, but it has to be recorded in some documentable environment, if that makes sense. So again, this slide deck that you're looking at, this is protected by copyright. It's original and it's recorded in material form, which is a Google Slides deck. And so it's now, I am the proud owner with my staff member of the copyright in this presentation. What that means is we didn't have to register anything, but if you guys who are watching this decide that you're going to take 3 or 4 slides, start your own legal business, and you start using what's on these slides to promote your business, you could potentially be sued by us for copyright infringement. And that's not a warning. I'm sure none of you would do that, but that's kind of how it works, if that makes sense. And so you can extend that logic to a lot more than just a presentation. Probably in startup companies where copyright comes up the most is in software. So software code, you write lines of code, it's recorded in material form, in whatever application that you do it in, that's protected by copyright. And whoever creates the copyright will own it. So if your software developer is writing your software code, the software developer owns the copyright at the time of creation. So the next question is, well, if you're running a startup company, it's all very well and good for the creators to own the copyright, but you want the copyright to be owned by the business. You don't want it to be owned by your employees or your contractors or whoever you've paid to do something for your business. You want to make sure you own the software code, you own the presentations. So the way that you do that with copyright is through contracts. And this is where it comes back to these service provider supply agreements. If you have a service provider, web developer, app developer, graphic designer, whoever designing some creative work for you, you want to make sure you have a contract with them that covers copyright. It can be included in what's called a contractor agreement or a service provider agreement as a paragraph that says any intellectual property created by the service provider will be hereby owned by the company. Or if you forgot to do it, or you just want to do something that just covers the copyright, there's these documents called an IP assignment deed, which we use a lot at Sprintlaw. So, these people sign a document that says all IP that I create, the second it's created on and from creation, will be owned by the company. So that's how copyright moves. And it's quite important if you're a startup to make sure not only that you own your brand name, but that you own all of your original works. This is what, particularly if it's a piece of software, this is what is going to be the core of value in your business. And you don't want it to be the case that you build your company out, you're selling heaps of copies of your software, and then some random developer says, hey, I still actually own part of that because I never signed any contract. Give me a piece of it or I'm going to sue you for using my copyright without my approval. Just got a question from Ashish here. What's the difference between registering a company name and a trademark? And if there is one, is a company name registration enough to protect you from using the name? Excellent question. They are quite different, and it's one of probably the biggest mistakes that I think startup founders make is they look on, ASIC, which is the website in which you register your company name, and they see that the company name is available, and they think, I got it. It's my name now. I own it. The registration of a company name or a business name is a legal requirement. You have to have a name for a company. And if you're a sole trader, but you're actually marketing yourself as something other than your personal name, you need to register the business name. And the reason for that, the logic for it is if someone sees that name and wants to know who's behind it, they can look up the public register and find out who's behind it. So it's really about a registration requirement. It's an administrative requirement. And as part of that, you cannot have two companies or two sole traders with the same name. That's your legal name for administration purposes, but it gives you no proprietary rights in that name. You don't own it. So we registered the name Sprintlaw Pty Ltd, but if we didn't have the trademark for Sprintlaw, let's say Legal Vision decided to launch a new product called the Sprintlaw offering, for example. It's not a company name, but they're still marketing themselves as Sprintlaw. They've maybe got a website for it. They're promoting it. I was able to nab the company name, but if they had the trademark for Sprintlaw and they're using it, they can say, hey, you guys can't use this name Sprintlaw just because you got the company name. So, and so they could actually stop us using it even though we have the company name, and vice versa. So the trademark is a much stronger protection. It gives you like a monopoly basically on that name, whereas the company is very much the company name is very much an administrative requirement. So very important to do both. Sergey's asked, is there a specific reason why there are exhaustive lists of names, categories of types of IP that are listed in IP clauses in contracts? I've seen US templates that look like biblical scrolls. So too have I with the US contracts. They've got a very different legal culture there. Some people joke that US lawyers like to make legal documents so complicated, so you have to pay them to read it. That's how they get people coming back. And I think that's probably true to some extent. There's really four main types of IP, which are the ones on the screen now: trademarks, copyright, trade secrets, patents. And so the most simple version of an IP clause will basically say, you, the creator, so let's say it's with a software developer, you, the creator of this software, assign all copyright, trademarks, trade secrets, patents, and then it will say circuit breeder rights, plant designer rights, and all kinds of other niche forms of IP. And then it'll say whether registered or unregistered, whether potential or actual, whether in Australia or anywhere in the world. So there's this very formal legal wording that's used. They're really talking about these four and different variations of these four. For trademarks, for example, well, I just said trademark doesn't really happen in a contract. It happens when you register a trademark, but there's these things called unregistered trademarks where, if people have been using a name for a period of time, they can argue that they should have had a trademark registration. So it's covering off some niche issues around trademarks with that wording. Similarly with copyright, there's special wording around past copyright versus future copyright. Trade secrets have about 5 different synonym names. I haven't really explained what these are yet, but they're sometimes called confidential information and know-how and various other things. And patents, the same. There's a few different types of patents. So lawyers will typically just, because IP is so important, want the most exhaustive list of intellectual property in the contract to be covered. If all it said was these four, it's probably fine for 90% of cases, but you'd struggle to find a lawyer that wouldn't want to have a pretty dense clause, because our whole job is about risk management. So we want to cover 100% of cases rather than that kind of 90%. Just moving on to trade secrets. So we've talked about trademarks, which is your brand name, copyright, which is your original work recorded in material form. Trade secrets are really intended to protect confidential information, so other stuff. This is probably the broadest area. So let's say you have an original idea for something and you came up with it, you've spotted a really big opportunity, and you don't want to tell people about it because they might steal it, if that makes sense. And this is often the case with founders in the very early stages. You've got an idea for a business, but you haven't done much on it yet, but you don't want anyone to steal the idea. Well, the problem is it's not trademark protected. You can't register the idea because this is about brand names. It's not copyright protected because you haven't really recorded it in material form. It's just a collection of ideas, but you do want people to not steal it. So what you can use are these NDA documents, which you've probably heard of, non-disclosure agreements. And often founders will use this in the early stages when they want to discuss business ideas with people or potential developers or potential suppliers. And even in the later stages when they've got a really big idea or opportunity that they don't want their competitors to know about. So when we talk about trade secrets, we're actually really talking about non-disclosure agreements and protect the kind of information that's protected in non-disclosure agreements. And so what I would say is if you have ideas that aren't yet at the stage of being copyright, a good way to protect them is to just make people sign NDAs before you talk about them too much. And then lawyers would say, well, you've now protected that as a trade secret. That's kind of what we call that kind of protection. So that's what that stuff's about. I will say on NDAs, like you come across some types of founders that make everyone sign an NDA before they tell you anything about what they've come up with. And speaking as a founder myself, oftentimes that's not a great way to go about making friends in the startup community, because really, I think there's probably some truth to the element that if you can tell someone their idea and then they can copy it, then it's not a very good idea, if that makes sense. So I think NDAs can be overused and people get a little bit too excitable with them. I do think if you have something genuinely confidential, or genuinely there's a risk if it's spread that it could be taken or cause damage to the idea, that you should be looking at sort of protecting them. Got a question from Joshua here. With tech products, how far can copyright protect you? E.g., Atlassian creates project management tools with drag and drop tasks, but obviously that itself is not copyrighted since other companies have also created similar products, or can this really only be tested in court? Good question. Yes, to some extent, it can really only be tested in court. I think copyright is whether something's been taken from whether copyright's been infringed will depend on whether you compare A and B, the original thing and the thing that's alleged to be infringed. Is it substantially similar, and can you show derivation? If you wanted to, if let's say Atlassian owns Trello, it's got that Kanban board view. Let's say I created a product called, Strello, and it also had the exact same layout and look and feel. Atlassian may allege copyright infringement against me for making the same Kanban board view type thing. They would say, we came up with this layout and format. I would say Kanbans are not original. They've been around for ages. Toyota used them. Like, you didn't invent the Kanban. They would say, yes, that's true. But if you actually compare the look and the user experience of your Kanban and our Kanban, they're very, very similar. Furthermore, we have records of you making an account with us, so we know that you derived it, and we know that you've likely copied it, and we're going to take you to court. The court's going to look at that evidence, and they're going to make a decision. It's not beyond reasonable doubt like you see in the movies. It's on the balance of probabilities. Is there an over 50% chance that this has actually been copied? And if the answer to that is yes, we think so, then you're going to be potentially liable. So that's kind of how it plays out in practice. A lot of the time, there's a lot of threatening to sue people for copyright infringement. People just settle out of court or change things. So there's not that much actual suing that goes on. But yes, it is in a sense something that can only be tested in court. Dan, I'm conscious we're at 7. I'm happy to keep going for a bit, but should I wrap up, or what do you reckon?
Yeah, maybe we'll take kind of like one final question. If anyone wants to kind of like, chuck up the hand, if there's any burning questions or things you want to better understand for your own business or own ventures. Harry, is that a mic off from your end? Do I see a mic off? Going once, going twice, sold. All right, I think we'll end it there. Was there much left in the slides? Quick run. Oh, okay, Serge wants to see a speed run.
Yeah, look, I just was going to talk a little bit about, I think maybe I'll do another session in the future, Dan, just about capital raising. It probably deserves its own sesh if you're open to that. And then I was just going to talk about building a team, which is really about making sure you comply with the regulations and then have contracts with all of your team. And that's pretty much it. The only other thing I didn't cover are patents, which just to quickly describe what they are, and again, not super relevant for a lot of companies. They are for inventions that you might make that are really, really innovative, a new drug, a new robot or something that pushes forward human progress. And they cost a lot of money to register, but if you can register a patent, you have the exclusive right to use that invention that you've made, and people have to pay you for the right to use it. So if you're working on a high tech or deep tech startup or something in the pharmaceutical space, this may be relevant. But for most like standard run of the mill companies, if you're building an app or something, it's unlikely to be patentable. So that was all I wanted to say. But yeah, hopefully that's your speed run for you.
Awesome. Alex, mate, thank you so much. I think I'm going to tell my brother to drop his law degree and just watch the recording this instead. I learned a shit ton. Might even be worth like a newsletter or a content piece. Like, I think like, yeah, for like, as I know, like, again, for John and myself, is in like the literacy. If you didn't study law, okay, starting a business actually involves a lot of very like complex legal things. So super cool with that info. And folks, yeah, in case you missed part of the session, we'll shoot a recording across in due course in our founders channel, but also in the kind of general events channel. Easy. Thanks so much, Alex. Have a good one, Sam.
Thanks, guys. I'll see you later.